So, in this chapter on fundamental rights, now I would like to speak specifically about Article 12 and 13, and in the context of 13, the concept of judicial review. So, the discussion is on Article 12 and Article 13, and within 13 I am talking about the concept of judicial review, or how Article 13 brings in judicial review. So, Article 12 and 13 is my discussion. So, in fact, when I was talking about the significance and the nature of the Indian Constitution, in the nature of the fundamental rights, I said one of the nature is fundamental rights is enforceable against the state. I said it is enforceable against the state. Now, what is the state all about? I said all organs of the government, I said, but still the constitution makers defined the state very clearly for us through Article 12. So, Article 12 is the definition of the state. Definition of the state. And as per the constitution, or Article 12, it means that the state includes government and parliament of India. So, what all are there? The government of India, that executive and legislature, executive plus legislature of India. So, government of India. Then executive and legislature of the state, executive plus legislature. That means the legislative assembly, all, and the chief minister and the entire executive of the states. Then it also include all the local authorities, the local bodies, all local bodies. So, panchayat, municipality, municipal authority, all will come under or any other authority within the territory of India or under the control of government of India. So, it also says any other authority, any other authority within the in a territory of India or under the control of government of India, within the territory or under the control of the government. So, this includes, so when we say any other authority, this will include all public sector units, even a public-private partnership, public sector enterprises. See, for example, Indian Rail, it's a public sector arrangement, public sector unit, or maybe Indian Oil Corporation. If you are not getting if some official of the Indian Oil Corporation is violating your right, it will also come under the state. Any violation done by such people, you can directly go to the court. And public-private partnerships, because if the substantial public funding is involved, then that authority also will come under the definition of the state. Now, in the whole definition, so any authority where there is a control emerging from, or if their authority is because of the presence of, because of the government of India or government of the state, then we can approach the court if they violate your rights. But in the whole thing, one authority which is missing is judiciary. Please see, judiciary is not mentioned in this definition of Article 12. But that does not mean that judiciary also can violate, because in various judgments, Supreme Court has mentioned that even judiciary will come under the definition of 12, to the extent that even judiciary cannot violate the rights of individuals without any reason or other. They can violate your rights. Judiciary can sentence you to jail term, but they have to follow the procedure. Even, meaning that means even judiciary cannot arbitrarily violate an individual's rights. an individual's rights. Okay. Even judiciary cannot arbitrarily violate an individual's rights. Individual's rights. So, definition of Article 12 does not, in the definition of Article 12 judiciary is not mentioned, but Supreme Court has clarified that even judiciary will come under the broad definition of state, and judiciary cannot violate the rights of individuals arbitrarily. So, that is the concept of Article 12. Article 12 clearly defined, because fundamental rights are enforceable against the state. The who all belong to the state is very clear: the central government, the union parliament, the state government, the state legislature, the local self-governments, public sector units, public-private partnerships, even a government-aided institutions, all will come under the definition of the state, because substantial funding of the state is involved in it. And these organs of the state, or where they draw power from the state, or government's funding is involved in that, if they violate your fundamental right, you have a right to approach the court directly. So, that is the meaning of the definition of the state, so that individuals can approach the court directly if these institutions violate your rights. So, what is definition of the state? That is Article 12. Then Article 13 is very interesting. Article 13 provides for judicial review. Article 13 says laws inconsistent with or in derogation of the fundamental right. What will happen to the laws which are inconsistent with the fundamental rights? See, now what you should understand here is, in India, even before the constitution came into being in 1950, many laws, many British laws were there. We had many British laws, or British India passed many laws. We have not discontinued any of, all these laws are allowed to continue. So, the CRPC, CPC, the Criminal Procedure Code and all, it was framed in 1860s. And we are still continuing with that. Many of these laws are made by the British, and we are still continuing with that law even in 2020. So, but what is the difference now when the new constitution, so when the new constitution came, we said that all the existing laws will continue, but on top of it we have the new laws. So, in 1950 fundamental rights came. Now, some of these laws can be, some of these laws which are already prevalent, or in future when it is made by the parliament, if there is a conflict with fundamental rights, what will happen? That is the question. So, Article 13 says any law, any ordinary law which is there, if it is violating the fundamental rights, such a law should be declared invalid immediately. That is the purpose of Article 13, wants to make it very clear. And who can make it invalid? The judiciary, the higher courts, the Supreme Court and the high courts are given the power to declare any law invalid because it violates the fundamental rights. So, Article 13(1) says, Article 13(1), they want to make even the pre-constitutional law and the post-constitutional law. It says all laws in force in the territory of India, all laws in force in the territory of India. So, we are talking about all laws in the territory of India immediately before the commencement of the constitution, immediately before the commencement of the constitution. So, we are talking about all those laws which were which were prevalent or which were in force in the territory of India just before, immediately before the commencement of the constitution, if they are inconsistent with part 3. Now, if those laws, if they are inconsistent, or if it is in conflict, if they are inconsistent with part 3, that means with fundamental rights. If they are inconsistent with part 3, then such laws shall be declared invalid or void, comma, then such laws shall be declared void, void means invalid, to the extent of inconsistency, to the extent of inconsistency. To the extent of inconsistency, such laws should be declared invalid. So, what is that? Again I am repeating, you please see, it says all laws in force in the territory of India immediately before the commencement of the Constitution, if they are inconsistent with part 3, if they are in conflict with fundamental rights, such laws shall be declared void by whom? By the Supreme Court or the High Courts. So, such laws can be declared invalid or void to the extent of inconsistency, to the extent of, so to the extent of it violate, to that extent, that much portion should be declared invalid or void. So, any what is the bottom line of Article 13(1)? Bottom line is any pre-constitutional law, any law which is prevalent in the country and which is still continuing after the Constitution came into being, any pre-constitutional law, if it violates fundamental rights, such a law should be declared invalid. That is Article 13(1). Similarly, Article 13(2). Article 13(2) says the state shall not make any law which takes away or abridges the rights conferred by this part. That means 13(2) says any post-constitutional law or any law passed by the Parliament shall not take away or abridge the fundamental rights. So, any new law made by the Parliament should not violate fundamental rights. So, it is very clear, the state shall not take away any law or sorry any fundamental right through a law. So, any post-constitutional law shall not take away or abridge the fundamental right. So, if it abridges or violates, to that extent such a law also should be declared invalid. To that extent, to the extent of violation, such a law shall be declared invalid. To the extent of violation, such a law shall be declared invalid or void. So, Article 13 says any pre-constitutional law, if it violates fundamental rights, it should be declared invalid, and 13(2) says any post-constitutional law, if it violates fundamental rights, that should be declared invalid. So, what is this law? Now, Article 13(3)(a), it also clarifies this law includes, the word law includes any ordinance, any order, any bylaw, any rule or any regulation, any notification, notification, any custom or usage in the territory of India. Okay. So, any notification, any custom. So, basically any ordinary law, this word law includes any ordinance, any order, any bylaw, any rule, any regulation, any notification, any custom. If it violates fundamental rights, such a law should be declared invalid. So, any law made, even law in force includes any law passed or made by a legislature, a state government or a competent authority of India, and immediately before the commencement of the Constitution or after the commencement of the Constitution, all of them should be declared invalid. So, and who will declare it is invalid? This will be done by the judiciary, the higher judiciary. This will be done by the judiciary and this will bring in judicial review. This will be done by high courts and Supreme Court, and this brings in the concept of judicial review. Judicial review. Now the question is, what is judicial review? So what is judicial review? In nutshell, judicial review is the power of the Supreme Court or the high courts to declare a law invalid. It is a power. In fact, if you broadly define judicial review, it has more power. Like, judicial review is the power of the Supreme Court or the high courts to declare a law invalid. Not only a law invalid, even any executive action invalid. It also includes any executive action, any action by the Prime Minister, any action by the government invalid, any executive action also invalid. It is broad, but in this context of Article 13, judicial review means it is the power of the Supreme Court or the high courts to declare any law invalid. Why? Because it is in violation of the fundamental rights. So judicial review is the power of the high courts and the Supreme Court to declare any law invalid or any action by the executive invalid on grounds of violation of fundamental rights, on grounds of violation of fundamental rights, or violation of the Constitution in general, or violation of Constitution in general. So again I am repeating, judicial review is the power of the Supreme Court and the high courts to declare any law invalid or any action by the executive invalid on grounds of violation of fundamental rights of individuals, or in general we can say in violation of the Constitution. But under Article 13, it is very specific. Article 13 says that no law shall violate fundamental rights. So we are only concerned about fundamental. If a particular law made by the Parliament or the state legislature violates fundamental rights, or any pre-existing, a pre-constitutional law violates fundamental rights, all those laws will be declared invalid. By whom? By the higher judiciary, by the Supreme Court or the high courts. So that is the meaning of Article 13, and this Article 13 brings in judicial review. See, judicial review is, please understand, this judicial review is not, judiciary is not reviewing fundamental rights. We say Article 13 brings judicial review to fundamental rights, we say, please understand, Article 13 and this judicial review is not about fundamental rights. That means judiciary is not reviewing fundamental rights. Judiciary is not reviewing fundamental rights. What are they reviewing? Judiciary is reviewing the ordinary laws. And what are we checking? We are checking whether these laws are violating fundamental rights or not. If it violates, it's something like, the court is made as the protector of the fundamental rights. Court has to check whether somebody is violating. It's something like, when young kids play in the ground, the parents go behind them. What is their parents' duty? To ensure that the kids are not being, injured, or, no external force will come and harm the child. No dog should come, or no big children should not bully them. So the parents will be always watching the small kids. Similarly, fundamental rights is like a small kid. It is the duty of the judiciary to ensure that no law will come and violate the fundamental rights. Any law passed by the legislature, any pre-existing law also, or even in the post-constitutional law, if it violates the fundamental rights, such a law will be declared invalid, not the fundamental right. Fundamental right will continue. Fundamental right is supreme. Fundamental right is much above the other things. So it is the duty of the Supreme Court and the high courts to ensure that our fundamental rights are protected. It is not violated. Who can violate? The legislature can make a new law and try to violate the fundamental right of the individual. Supreme Court will interfere or the High Courts will interfere and say this is a violation of the fundamental rights, so such a law should be declared invalid, should be declared as void. So Article 13 brings in judicial review to protect fundamental rights from violation by the ordinary laws passed by the Parliament. So that is the meaning of Article 13, and I have already talked about Article 12. It defines what is state because the fundamental rights are enforceable against the state. And Article 13, no law shall violate fundamental rights. But this word law is specifically about ordinary laws, not about the constitutional laws. Constitution, what is written is different. We are specifically talking about any law, pre-existing or post-constitutional, should not violate fundamental rights. So that's about Article 12 and Article 13.